That is case number 104565, State of Kansas v. Katron Harris.
The appellant appears through counsel, Michelle Davis, and may I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Thank you. The evidence in this case was that Mr. Harris joined up with a friend for a walk, and they went to an acquaintance's house, the friend's acquaintance's house, and Mr. Harris was standing outside, and the friend comes out of the house and says that he's going to rob this acquaintance, this individual. This individual is a drug dealer and is known to have money on the property. And so the man who actually shot the victim in this case was convicted of that crime, and he's in prison. He comes back out and he tells Mr. Harris to act as a lookout, and it's on that theory that the state prosecuted Mr. Harris for aiding and abetting. And they prosecuted him for aiding and abetting an aggravated robbery. And in the course of that aggravated robbery, that basically felony murder. And the state instructed the jury, charged Mr. Harris that the taking was accomplished by threat of bodily harm. And not that the taking was accomplished by force. And it's our contention that while there may have been evidence to support a taking in this case by force, that there was insufficient evidence that the state did not prove that the taking had been accomplished by threat of bodily harm. And the evidence in this case, there was no eyewitness testimony as to what happened at the time that the man was shot. So basically what the state proceeded on was Mr. Harris's statement to police. And then you have the evidence at the scene. And the police did a good job. There's a really good video in the record that has a detailed video of the scene of the crime. And then the third thing to rely upon is the coroner's testimony regarding the shots that the victim suffered. So what I basically was going to do is just sort of summarize what that evidence showed. And I'd like to begin with the video of the scene because basically you have a garage, you walk through the garage, and there's a small living room, and from the garage you can see into it. It's a very small kitchen, and that's where the victim was found. And if you stand at the doorway of the kitchen and to your left, there's a counter area and a sink. And what the police found was that the water was running, and the head of his body was right near that sink area where the microwave is and where he was cooking. He was cooking crack cocaine at the time. There were 2 witnesses that testified about that. The detective said that he was cooking crack cocaine. The microwave door was open. And then, so you're standing on the doorway of the kitchen, and all that's on your left, his head and the counter and the running water in the sink. And then the kitchen's small enough that as his body's laying there, his feet are on the other side of the kitchen, which is by another door, a closed door. And on the right, there's a refrigerator. And then there's a little bit of space there between the refrigerator and the open doorway. And if you keep watching that video and you watch it all the way through, it comes back to the kitchen and it shows that counter area. And there's blood on the front of the sink and running down the counters, and there's blood on the microwave. So I think the evidence is pretty clear that that's where Mr. Harris was shot because of the blood that is there, located in that area, and that's where his head is. And then the other evidence that supports our argument is that the gunshots, there's a couple witnesses that testified that the gunshots were in his back. He was shot in the back.
There were 2 in the front of the chest, though.
No, that's not what the evidence shows.
There were no wounds to the chest?
No entry wounds. What the coroner testified to, the coroner basically kept saying when they went through the different gunshot wounds, and you have to be careful here because the coroner labeled all of the entry wounds with an alphabetical letter. None of the exit wounds are labeled. The coroner says these are all entry wounds. This is A entry wound, B entry wound, C entry wound. And then the coroner says we have some exit wounds for those. And sometimes the coroner would say where the exit wounds are at. And that's where I think you're coming from, Justice Johnson. The state's trying to claim that some of those exit wounds were actually entry wounds. But all of the entry wounds have alphabetical letters. Then the coroner says there's some exit wounds, and the coroner sometimes can identify which entry wounds were exit wounds. And then the coroner says some of those bullets are just in the body. So some of them we don't have exit wounds for.
What about the gunshot wounds to the left forearm.
Right. There was one to the left. I think it was in the thumb area. There was an entry wound on the front of the wrist, or the back of the wrist, I'm sorry, and the coroner identified it as lining up with this thumb area here. So I guess I would call that the back of the wrist.
The state suggests that you can draw an inference from that as a defensive wound, and therefore there's at least some evidence of the force of threat. What's your response to that?
Anything's possible, right? You can say anything's possible. It's possible the bullet hit a wall and came back, and I mean, you can argue anything's possible, but I think you have to have some evidence to support that inference other than just speculation and possibility of what could have taken place. I think the state it's the state's burden here to prove. And the state has to do more than just say it's possible when a bullet wound enters a body that the body could have been positioned at such an angle that it could have come from the front when that's all just speculation.
Was there any evidence about the order of the shots?
No.
Okay. Because a bunch of them were at least potentially not life-threatening in his limbs.
That's correct, and the coroner did testify about that.
Okay.
And then to go back,
You're suggesting here that there's evidence of force, but no evidence of threat of bodily harm. Is that right?
yes.
And does it take a conviction for a underlying felony to satisfy felony murder? I mean, you already acknowledged that there's sufficient evidence of force.
Yes.
And even if we were to find your theory that there wasn't threat, certainly there's evidence of an aggravated robbery, which you suggest there is because there's force. So is there really a difference here in terms of the underlying felony murder?
Well, yes, because the state charged aggravated robbery by threat of bodily harm, and then in the jury instructions, the judge incorporated those elements as the elements of felony murder. So that is what the jury was required to find. The state didn't charge this as a general robbery. The state specifically charged this type of robbery and used this type of robbery specifically as the basis for the felony murder conviction. So I want to go back to your point, though, Justice Johnson, because I have more to say about that. I think
before you get there, I want to follow up on this. Okay. So what you're saying, we've repeatedly said that a conviction for ag robbery in this case would not be necessary to be guilty of felony murder, just where we're getting at. Are you trying to say that the jury would not have known there was sufficient evidence to support one theory of ag robbery because they weren't instructed? Is that what you're saying?
They were never instructed to find whether there was force or not. That was not charged by the state. The state only charged this one means. This is not an alternative means case. They only charged the means of taking by threat.
And let's take that one step further then. You seem to concede that there is sufficient evidence from which the jury could find ag robbery by force. But isn't it a taking from the person or presence by force? And if you kill someone, can you commit aggravated robbery on a corpse?
I don't
because the taking occurred after the victim was down and perhaps dead, right?
That's true. And then the evidence was Mr. Harris said that the man who shot the victim then went through the house and took some money, took a box, took some money. I don't know if he specifically said box, but that was the state's evidence that a box with money was missing.
But I guess my question is, what kind of nexus does there have to be between the force and the taking?
But I don't know that we need to really decide that because the state never charged force. The jury was never instructed upon it. So from a basic concept of due process, he had no notice to defend against that element.
Now tell me what you wanted to tell me about the wounds.
On the, you just have to read that coroner's testimony really carefully. It's 11-823. The coroner kept saying the gun has to be behind. The gun has to be behind. He said there were 3 front exits. The state's trying to argue H and G are entry wounds. The coroner's really clear. He says we're looking at the front of the body. There's 3 exit wounds, and those are from bullets M, H, and J. He said there's 1 side entry, which is G. So the closest you can get here is a side entry. That's it. And then he says G exits on the hip, on the side of the hip. He says H is an entry. H is an entry wound. But he doesn't say where. Okay? But the coroner is very clear that H has a front exit. But he doesn't tell us where H enters. So I think you have to read that testimony very carefully, and then it establishes what I'm saying. The only other thing I wanted to, are there any other? I think I've said enough about that issue.
Well, I want to go back to initially. Wasn't there a discussion between the three of them that they were the express purpose of going into the home was to take property?
I think that what Mr. Harris told the police is that I didn't believe him. Harris kept talking about robbing somebody. And so he didn't believe him. When he said, we're going to this acquaintance's house, Harris says, I'm going to rob.
And they knew there was some money there. They knew there were drugs.
Not necessarily that Mr. Harris knew. This was a friend of Gibson's. Gibson had worked at this place.
But Harris was involved with it in the discussion, wasn't he?
No, not necessarily. He denies that. He says that they're just talking about it. Harris is talking about it. This is Harris's ball game.
Well, there's some evidence of that.
The only time that he's really put on specific notice that he's going to rob this place is when he comes out. He comes out and he says, I'm going to go rob the guy. You act as a lookout. Before that, he had just thought it was talk.
So basically, under your theory, there's no robbery here. It maybe was an aggravated burglary. They went in with the unauthorized entry and to commit a felony or a theft therein. Is there no felony committed other than the homicide?
Mr. Harris's defense at trial was, I did not aid and abet this aggravated robbery. They told me to stand outside as a lookout, but I didn't do it. I was just with the wrong people, wrong place, wrong time. That was his defense. It's my contention today that the state did not prove the aggravated robbery that it charged, and it did not prove the felony murder that it charged. That's my contention. The other evidence that I wanted to point out was that the victim in this case had a loaded gun in his pocket, and that further supports that this was a trial by ambush, because there are witnesses that testified that, I'm not going to say they testified, but the implication is obviously that he would have tried to use the gun to defend himself if he had been able to do that. The other issue that I wanted to cover briefly was the alternative means issue, because I don't think this court has ruled. It's a killing in the commission of, the attempt to commit, or the flight from. And this court has not ruled yet as to whether those are alternative means, and so I just want to touch upon that briefly. It would be our contention that those are a different causation. That is a causation element. It's when was the killing committed, and as Justice Johnson pointed out, the killing has to be committed in the commission of, the attempt, or the flight from in order to qualify for felony murder. So it's a causation element. And
it seems to me that the gravamen of the felony murder is involvement in an inherently dangerous felony that results in a death, and that the attempt or in the commission or fleeing simply sets the temporal boundaries of when that inherently dangerous felony is being committed, when you would be involved. And so why is that an essential element? Why does that fit into the gravamen of the offense when it really is describing? It doesn't make any difference whether it's in the front end, in the middle, or at the end. If it's during, then that fits the definition.
Isn't that kind of the causation? Maybe we're just saying the same thing. I guess I see that as a causation thing, because if the causation is that there was an inherently dangerous felony occurring, I don't see that as causation as to whether the death was at the beginning, middle, or the end. The causation was involvement, and to me, all that language is telling us is what involvement means from the beginning to this end. Well, I guess it's just our contention that does then lay forth specific different. I think the standard is that it lists different elements, lists a different causation element, and I'm calling it causation, but that these are different different acts, I guess, might be another way that we're arguing it, whether it happened during the commission, the attempt to commit, or the flight from that temporal that you're talking about would constitute a separate act as for alternative means purposes.
Isn't the causation death? These acts cause death. That's what you have to prove. So I think that's the causation element.
But I'm thinking of it in terms of if you stretch Justice Johnson's argument and say he had gone in and shot the guy, and then later they came back and they robbed the place, that's where I'm thinking in terms of causation, perhaps. That it has to be this temporal proximity.
He bled out, didn't he? Wasn't the coroner's testimony that he died from internal bleeding?
He would have died fairly quickly. I think it was within minutes. Okay. But just as a hypothetical. Okay.
Do we get to your issue because it was raised for the first time on appeal?
I'm sorry.
Do we get to the alternative means issue since it was raised for the first time on appeal?
It's our argument that you should, because it implicates a fundamental right to jury unanimity. And so it meets an exception that can be raised for the first time on appeal. That was the argument in my brief.
Is the fact that it's a statutory right, how do you get to a fundamental right when it's something that's statutory and not constitutional?
I'm sorry, I had considered it to be a fundamental right even though it was statutory, that I had not seen a difference there between a statutory right and a constitutional right.
So what's your basis for saying it's a fundamental right?
The state didn't argue that, and I'm just not prepared to address that question today.
Can you give us any guidance on how we would discern the difference between the two? Not necessarily on this case, but for future reference?
No, other than I had just, even if it was just that same common sense thinking as, I don't know if you want to call it common sense, but my thinking of it, a fundamental right can be a statutory or constitutional right. And beyond that, no, I can't.
Well, was this case pending on appeal when the Wright case came out?
I'm not sure.
Well, and then what about the Brown case? I mean, typically we say that when we change our parameters of how we look at the law, that we will apply that to all cases pending on appeal, and typically then that means that they haven't been fully vetted at the trial level, doesn't it?
Yes, I agree with your argument, Justice Johnson.
Do you have any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. May it please the court, Cheryl Lidke on behalf of the state of Kansas. My notes reflect that there were entry wounds to the chest of the victim. I think you'll find those at the record, volume 11, pages 822 and 823. Dr. Mitchell testified that gunshot wounds G and H entered the chest of the victim and exited through his back. So the reason I bring that up is to point out that we believe there was other things besides the defendant's confession to police that showed how these injuries were inflicted.
You make a number of arguments describing support for the fact that the robbers did place this victim in fear of bodily harm before actually killing. But what evidence is there that the taking was by fear of bodily harm?
Well, I think the case law says that the threat of bodily harm has to occur before or during the taking of the property. So our argument here today is that the threat of bodily harm occurred before the taking of the property.
Well, it happened before, but the statute says that ag robbery is the taking from the person or presence by fear of bodily harm.
Right.
And you can't have both a threat and a taking without having a connection.
Right.
Can you?
Correct.
And that's my question is we can infer there was some fear of bodily harm perhaps before the trigger was pulled, but how was that a taking by the fear rather than a taking by the force?
Well, I think you can also infer from the evidence that the taking was going on while the shooting was still occurring. If you recall the confession of the defendant, he said that Mr. Gibson was running through the house at the point that he was asked to come in and do his work. In other words, when he was asked to come in and fire shots to finish off the victim, he said that Kelvin Gibson was running through the house looking for the property, turning things upside down at that time. So I still believe that putting Mr. Martin in threat of bodily harm before the actual taking would be sufficient.
The temporal connection doesn't make the causal connection, in my mind. You can threaten someone, and if they refuse to give you the property based on threats, and you knock them down and jerk it out of their hand, have you taken it by force, or did you take it by the fear?
No, I don't think there was any evidence in this case, although I'm appreciative of the fact that they concede that there was evidence of force. This wasn't a case where the property was taken from him by force. This was a case where he was held at gunpoint and fired upon, and then his property was taken.
Stop there. What was the evidence he was held at gunpoint? It seems like the evidence was he had his back to the shooters and was cooking, and they came in, and a whole lot of shots are fired into his back. What's the evidence that they held him, or that he had any idea at all that they were attempting to take
I would
anything
respectfully
from
disagree
him?
with you.
Other than, what's the evidence that he
think-
would have been aware of that, or that?
I think, taken in a light most favorable to this state, that rational minds could agree that there was ample evidence.
What
For
is it?
instance, there is a defensive wound to one of his arms. The pathologist testified that that was a classic defensive wound, which would indicate that he saw what was coming his way. There were also chest wounds, which would indicate that he's still standing.
Well, again, what's the link between the defensive wound?
Because that indicates that he saw what was coming.
But he saw that he was going to be shot. Did he see that they were attempting to take property from him?
I don't think that that's what he has to see. I think that the threat of bodily harm is what we look at from the subjective point of the victim's viewpoint.
Well, the statute requires a taking of property from the person or presence of another by threat of bodily harm.
Right.
They're taking it from the person's or presence. What were they taking from his person or presence
They were
as he
taking-
stood with his back to them when they came in?
Well, I don't think it's correct to say that he stood with his back to them as they came in. The evidence was that Kelvin Gibson, who was one of his friends that he let into the home often, was there that day and had been let in by the victim. There were some people who came in to buy dope from the victim who testified that they saw Kelvin sitting there in the living room. One of them said that they saw him out in the garage.
Well, that's before this all transpires.
But that is to point out that I don't think he was ambushed. I think surprised by the fact that he was being taken advantage of by one of his acquaintances, one of his own friends. But he was there. The way that, if you look at the crime scene video, the way that his body was positioned, it's as if he was backed into a corner into the kitchen and had no way out, was shot, and then fell forward. And so his head is out towards the exit, towards the kitchen. So I think the position of his body, the nature of his wounds, the fact that there are front side wounds as well as a defensive wound, indicate to me and to reasonable minds that he saw at least part of what was coming towards him. And if you have a gun being fired at you, I think a reasonable mind could say that the logical connection is you're going to feel threatened. And that's the piece that I think is subjective. I don't think that Philip had to know that his property was being rummaged through and being taken. I think that is...
What does by mean?
I'm sorry?
What does by in the statute mean? It's the taking of the property by threat of bodily harm.
Correct.
And doesn't that connect the taking with the fear? I mean, if you're accosted with a deadly weapon, you're the victim of an aggravated assault.
Right.
You're not the victim of an aggravated battery.
Well, the cases I reviewed said that the threat of bodily harm has to occur before or during. It can't happen afterwards because then, of course, you wouldn't have a taking of property by force or by threat of bodily harm. I've not read any cases, though, that say that the taking it from the presence of the victim, that he has to understand and still feel like he personally, it's being taken from him, from his presence.
Well, I didn't mean to suggest that, and I probably didn't word that correctly, but I was trying to get you to focus on whatever evidence there is that the property was taken by threat of bodily harm.
Yeah, and I think the only evidence is what I keep saying, is the nature of his wounds, the position of his body.
And why isn't that just evidence that he saw what was happening and tried to prevent it, as opposed to evidence that there was a taking of property by threat or bodily harm? How do you make that distinction? What's the evidence that ties those two things? As opposed to just, oh, I'm going to be shot, I don't want to be shot.
Yeah.
I don't understand what the significance of that evidence is.
Well, and I think that's the same question that Justice Johnson is asking me, and I'm not. I didn't read the case law to say that we had to prove that he understood that the property was being taken.
I'm not saying
from his
that.
presence.
Nothing about what he understood. How does evidence that he had if he did have 2 chest wounds and he had a defensive injury to his left wrist, how does that evidence indicate a taking of property by threat of bodily harm? Talking about what he knew.
I think it proves a threat of bodily harm.
Okay.
And it proves an ag assault, because just placing someone in fear of bodily harm would be assault, and since he had a weapon, it would be ag assault, correct?
Well, if you didn't have the taking of the property from his presence that was occurring during this shooting, then maybe you would just have an aggravated assault.
What you're saying is that he would have seen this coming and would have had fear. At that point, you proved an ag assault. Would you agree with me?
I think that's a possibility.
And you haven't proved anything more than an ag assault until we have the taking of the property.
Correct.
And what I'm saying is, don't we have to connect up
Absolutely.
taking of the property? If they had come back the next day and taken property, you would agree with me that there had been an ag assault and a burglary, right?
Well, I would agree that you wouldn't have a felony murder that occurred during the commission of an aggravated robbery. Yes.
What's the logic in charging this guy and instructing the jury only on the threat of force provision and not just saying the taking by force? Why? I mean, I realize there's an irony in my question, because we're always beating up on you in the alternative means stuff. Why do you just take the pick?
And it hadn't been as settled then as it is now.
But I really am kind of puzzled by why you would charge it this way, given the evidence.
Well, honestly, I don't think that. I guess in my mind, the taking by force would have required some sort of physical struggle over the property, some sort of physical struggle between the perpetrator and the victim during the taking of the property. And I don't think there was any evidence that a physical struggle ensued between the two of them. I mean, I think the classic example would be, a woman's got her purse on her shoulder, and the robber is trying to steal the purse from her arm. There's an actual physical struggle between them where the property is taken by force. I don't think that we could say that when his money that was in a shoebox in his closet was taken, that there was a taking by force between the two of them.
I have one other question on the front entry wounds to the torso. You said earlier that there was an indication, or that was an indication, that the victim was standing when those wounds were inflicted. And I can't pull up the part of the record right now of the coroner's testimony on that. Are you saying that the coroner testified that those wounds were indicative of the victim being in a standing position as opposed to just your inference?
I am.
Okay. So I can just look to that and see that evidence?
Yes.
Okay.
I think at pages 822 and 823.
That's what I have here, but I just can't get those pages up right now.
All right. And at 819 through 20 is the discussion about the defensive wound to the left arm as well. There hasn't been any argument today regarding the second issue, but because it I think it is a personal I don't want to call it an attack, but a challenge to some of the things that I said during the trial. I wanted to touch on it. We don't believe that the judge abused his discretion in denying the request for mistrial. First of all, I'd note that the defendant didn't ask for a mistrial until after he had first asked that evidence be suppressed, and then when that was denied, then as a second request or a remedy, he asked for the mistrial. A lot is said about prosecutorial misconduct, but I hope the record reflected that in this case, the statement that I made was one out of emotion because the defense attorney, and I'm not saying that we have our right to say anything when defense attorneys have misconduct themselves, but in this particular case, in front of the jury, the defense attorney had claimed that we were withholding evidence, that we had never turned over evidence, which was not the case. I didn't call her a liar. I said that was false in front of the jury. But most importantly, I wanted the court to understand that the judge took us into chambers later that day and told both of us that we should consider apologizing to the jury and to the court. I chose to do that. They didn't, but I did. And so I think that if the jury got any message, they understood clearly the next morning when I apologized to them and told them that I was not intending to impugn the integrity of Miss Erickson, that cured any sort of prejudice that might have been caused by my statement. So I think the judge considered that along with the nature of the misconduct and decided appropriately, we believe, that there was no error that was preventing the defendant from getting a fair trial in this case. As to the third issue, we're asking first that this court find that felony murder does not create an alternative means issue. We believe that felony murder has two focuses, as Justice Johnson pointed out. There's a killing and there's involvement in an inherently dangerous felony. When it occurs, when the killing occurs, whether it's while attempting to commit the felony or while committing the felony or while attempting to flee from the felony or while fleeing from the felony, is not a crucial part of what has to be proven in felony murder. We've argued that those are just temporal aspects, the timing of the killing, and it's not what the focus of the statute is. I see that I'm out of time, so if there's no questions about that.
Did you do any legislative history on that temporal language?
No,
has it evolved over, because it seems to me that if, it's the kind of thing you'd start out in the commission of and inherently, and then someone says, oh no, it was already completed and I was fleeing, and that you end up, that's how these things normally come about.
Yes. The only history on it I could find was, it's not legislative, it's case law. In the Kleypas case, this court discussed it somewhat and called it a temporal requirement, the timing of the killing. But no, I did not look up the legislative history. I'm sorry.
Thank you. Do you have any further questions of counsel? I see none. Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
I just want to dispute the state's contention that the coroner testified about the wrist wound being a defensive wound. And I'm looking at volume 11, page 819. And the coroner says, he's talking about an exhibit, and they're showing him photographs, and he says it demonstrates gunshot wound D. And he says this is to the back of the left forearm. So the bullet's coming in on the back of the left forearm. And he says it exits at the wrist, closer down to the wrist. And he's talking about the gunshot exits on the thumb side. And that's it. There's no testimony about that being a defensive wound. I mean, that's all the prosecutors.
Well, the record is what the record is.
Okay. Fair enough. And then again,
Counsel, let Justice Johnson complete his question before you move on.
Okay.
I wanted to move to another area if I could, please. On the second issue, the statement by the prosecutor of which you complain was made to the judge,
Yes.
and it's the courtroom. One side jumps up, makes an objection. The other side jumps up and says, and makes their arguments. Why wasn't that merely an argument made to the judge about the objection interposed by defense? Perhaps it should have been preceded by, can we recess the jury or send the jury out? But why wasn't that fair argument on an objection? It wasn't an argument made to the jury. It wasn't part of closing argument, or it was just part of an argument against an objection being made.
I'm not sure I understand your question.
Well, if she had stood up and says, Judge, counsel is arguing facts not in evidence, would we say that was prosecutorial misconduct? No, we wouldn't. But instead she says, Judge, that's false.
She says, right, you're right. Mr. Harris's counsel objected, and she said...
I've got exactly. Judge, that's absolutely false.
Right.
And that's why isn't that akin to saying, Judge, counsel's arguing facts that are not in evidence?
Well, because it wasn't during argument.
It what?
It wasn't during argument. It was during an evidentiary portion.
It was during argument of an objection.
Right, right. But again, it's just that it's inappropriate to use the words false in referring to what defense counsel has said.
Do you have any further questions, counsel?
Are you still maintaining that the entry wounds, G and H, in the coroner's report were exit wounds instead of entry wounds in the chest?
Yes.
You're made to, so we'll just go to the record.
The coroner specifically said that H was a front exit wound. The coroner specifically said that. And the coroner said that G was a side entry wound.
Okay.
And that's specific there.
Okay.
Any more questions of counsel?
I have one more. Ms. Lidke mentioned that there was some evidence, I think, through the confession that as the defendant's firing the last couple of shots, there's someone roaming, one of the other accomplices is roaming through the house, taking property or the shoebox or whatever. Why isn't that evidence of that link that we're talking about between the taking and the threat? Does that make sense?
No, well, but there's no threat to Mr. Harris to allow the taking to be accomplished.
Well,
the threat has to allow...
She points out it's going on simultaneously.
But he's
while this defendant is shooting him, someone else is taking his property.
I don't think that the evidence established that. I think Mr. Harris said that they told him he had to put in his work, and so he stood in the garage and he fired one shot. And then he saw Mr. Harris going through the house to take property. So the taking is not by a threat to Mr. Harris, because Mr. Harris is laying face down in the kitchen, shot in the back. So there's no threat to him that is allowing another individual to go and take that property.
Thank you.
Can threat and force be simultaneous? So that if I'm shot once, and there's a threat of another shot, and in this instance there was action on that, with repeated shots, why aren't the successive shots, the fact that there were successive shots, a threat?
And I understand, I think what you're asking me is that in his mind, as he is being shot, he becomes aware that he is under threat. But the way the statute is worded is that the threat has to allow the taking to happen.
And it didn't.
So simply
he was unable to defend his property.
But the property wasn't being taken at that point.
Is that true even with the evidence of Harris saying that his accomplice was running through the house while Harris was shooting?
But that came later, because Harris is standing outside and he hears the gunshots. And then one young man comes out and says, you need to go and do something here. He's standing in the garage, he looks through the living room into the kitchen, the body is face down on the floor. So when he fires the gun at the victim, all of that, the previous shooting has already happened. So the victim's already been shot.
So let me make sure I understand. In order to ever have a case proved as a threat, as opposed to force, you have to have the person feeling threatened while the perpetrator is grabbing the stuff.
No, the threat has to allow the taking to happen. It doesn't necessarily have to be, but I mean...
So you can say, sit there, I have a gun, sit there, don't move. And then the perpetrator can leave the room, go to a different room, grab this stuff, person continues to sit there because they're afraid.
Yes, because the threat has allowed the taking to happen. Yes.
So the robbery would have to be complete before the death.
No.
Why not?
They were able to take the property because he had been shot in the back and he was laying on the ground. By force, they had taken him out of the equation. They did not use a threat to accomplish the taking of the property. They didn't need to threaten him anymore because they had already shot him. He was laying face down. They don't need to make any threat. Nobody needed to worry about him anymore.
Any further questions of counsel?
Well, let me see if I can clarify. You're saying that in this scenario, that the victim here did not try to stop them from taking his stuff because he was fearful of being hurt. He did it because he was physically incapacitated and was incapable of stopping them. Is that what you're arguing?
Yes, and the coroner's testimony supports that.
Do we know whether the victim was dead when Mr. Harris came in to do his thing or do his part?
We don't know that.
Okay.
Any more questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.